Good morning. Now, today we have counsel to the inquiry, Mr. McIntosh, KC, and I will invite him to give a final oral statement supplementing counsel to the inquiry's previous written closing statement.
Thank you, Lord. I'm joined by my co-counsel of the inquiry, Mr. Connell. But my proposal, my Lord, is to start with 3 preliminary matters and then ask 3 questions. We adopt our closing statement, the previous closing statements from Glasgow 1, 2, and 3. But first, I thought I should identify what is to come next. Today is the last hearing of this inquiry. It may assist those who are following online to appreciate that after today, my Lord faces the task of preparing a report that addresses the remit of the inquiry and each of its terms of reference, including the making of recommendations. Prior to the formal setting up of the inquiry on the 3rd of August 2020, the then Cabinet Secretary announced the terms of reference in Parliament on the 15th of June. In her remarks, Ms. Freeman made plain that the patients and families were to be at the heart of the inquiry, and that was a key factor in your decision to hear first from those who had been affected by the issues at the Queen Elizabeth University Hospital. It may also assist to explain that when my Lord has considered all the evidence and prepared his provisional conclusions, the inquiry team will advise those who are to be subject to criticism what such criticism is to be and the facts that support those criticisms. This process has been described as the sending of warning letters, or salmon letters, or even maximalisation. As Lord Maclean explained in the Vale of Leven Hospital Inquiry Report, which is Bundle 51, Volume 1, Document 2, page 258 at page 30, he explained in the second paragraph on the right-hand side, third paragraph on the right-hand side of the page there, the whole purpose of the warning letter process is to give notice to individuals and organisations of potential criticism, so that they have the opportunity of making the appropriate response to the proposed criticism. The warning letter process itself ensures fairness for anyone who may be criticised. The law will, of course, then consider all responses to such letters before submitting your final report to ministers, together with its recommendations. These, of course, may develop those made within the interim report published in March of 2025. My second preliminary point relates to safety and how it should be understood. In his oral submission for the board on Tuesday, Mr. Gray, KC, submitted the counsel to the inquiry have considered that something is unsafe if it involves an additional risk of avoidable infection to patients. He appeared to criticise that. That was our approach in the Glasgow 3 hearing. However, following focused and helpful submissions on this issue by Scottish ministers, we sought additional evidence and developed our views. These can be found in Chapter 3 of our closing statement, following Glasgow 4. We now appreciate that deciding whether a building or service is unsafe involves an assessment of both the likelihood of a harmful event occurring and the consequences of that harmful event. The test we submit applies is set out in paragraph 188 of our closing statement. That there are three circumstances, when a particular building system at the hospital would not provide suitable environment for the delivery of safe, effective, person-centred care. The first is that no attempt has been made to apply the conventional framework of risk management and to evaluate the level of risk posed to patients. The second is where there is evidence to support the conclusion that in respect of an identified hazard, the likelihood and consequence of an identified harm occurring would give rise to a high or extreme risk in a particular patient group, and there's been no mitigation to reduce the risk to an agreed acceptable level. And the third is where such mitigation in place, there is evidence for reasons that could reasonably have been anticipated that it's not applying consistently or would be not effective in all cases. We have therefore not assessed the question of whether any part of the hospital was or is now safe against the standard we were using in the Glasgow 3 hearing, but against the standard developed in Chapter 3 of our closing statement following Glasgow 4, and we've set out those conclusions in our closing statement. The third preliminary matter is the issue of the criticism advanced of counsel to the inquiry. On behalf of the Health Board, Mr. Gray has submitted that he continues to maintain the criticism of the way we ask questions of certain board staff, advanced in paragraphs 16 to 21 of the board's closing statement following Glasgow 3. We've addressed this issue at length in paragraphs 124 to 136 of our closing statement following Glasgow 3. Whilst we did ask some robust questions of witnesses, those were asked when those witnesses did not answer questions or could not explain inconsistencies between their position and documents. In our submission, we were right to do so. The inquiry is charged with examining events of the utmost seriousness. It is important that the evidence heard is put to the sternest test. Furthermore, many of our questions were asked because of specific requests by counsel for other core participants in the informal Rule 9 process. NHS GGC has also taken advantage of that process. It's quite likely that many questions that have aggravated the board have been proposed by other CPs whose specific perspective of events is opposed to that of NHS GGC. Had these concerns been raised during the hearing, we could have responded, but that was not done. In any event, we now understand that these concerns only crystallised after the hearing when the board read our closing statement following Glasgow 3. Our conclusions are matters of fact, which, if I understand its evolved position, the board now accepts. My Lord, I turn now to my substantive submissions. My proposed approach is to reflect on the task that the inquiry team has carried out over the past 5 years and then address 3 questions. The 3 questions are this: what went wrong with the procurement and why? What harm was caused by the deficient features of the building? And how can this be prevented from happening again? Reflecting on the task we've carried out, the task of the inquiry team has been made more difficult. NHS Greater Glasgow and Clyde have long insisted that there was no evidence to back up the concerns over patient safety at the Queen Elizabeth that caused the inquiry to be established. The clearest example was paragraph 63 of their first positioning paper from December 2022. I won't put it on the screen, but it's bundle 25, document 10, page 362, which that document was adopted as one of the appendices to the board's closing statement following the Glasgow 2 hearing in August of 2023. As a result, much of the work of the inquiry team has been spent on attempting to work out whether there was a link between patient infections and identified unsafe features of the water and ventilation system. The Health Board has now reached a delayed acceptance that it is more likely than not that a material proportion of the additional environmental relevant BSI in the paediatric hemato-oncology population between 2016 and 2020 had a connection to the state of the hospital water system. My Lord, that concession substantially reflects what the Case Notes Review concluded in March 2021. There needs to be some acknowledgement that how the Health Board approached this issue has severely impacted on the work of the inquiry. The 3 impacts that we say are principally the issue are as follows. The inquiry team had to investigate the alternative, now abandoned, position of the board in positioning paper 1 itself, and the specific arguments set out in the appendix produced by the NHS GGC Director of IPC that included the suggestion that the existence of significant social deprivation in the city of Glasgow may have influenced the rates of hospital-acquired infections in the Schiehallion unit, which, as Lord knows, has a catchment area covering the whole of Scotland. The second impact was the inquiry's appointed experts had to design and carry out their own epidemiological studies without the data that was produced by NHS GGC for the authors of what we then eventually called the HAD report, that is, Professor Hawkey Dr. Agarwal and Dr. Drumright. Thirdly, when the inquiry team sought evidence, including opinion evidence from persons of skill, from those who worked at the hospital who considered that there was a concern for patient safety arising from building systems, including the former lead infection control doctor, Dr. Inkster, and microbiologists, including Dr. Peters and Dr. Redding, we were told in no uncertain terms that their evidence on all points should be rejected because they were aggrieved. I now propose to turn to my first question. What went wrong with the procurement and why? 24 years ago, the NHS in Glasgow decided to build a new hospital. As Dr. Armstrong, the medical director, put in her evidence last year, column 21 of her transcripts, NHS Greater Glasgow and Clyde thought it was getting a fantastic hospital that had been working on for a long time, but did not get what they were expected. We are clear that the Health Board did not mention the decision not to follow Scottish Government guidance on ventilation in the wards of the hospital, what we've called the agreed ventilation derogation, in its full business case. That meant that when the procurement was approved by Cabinet in December 2010, the Scottish Government did not know of that significant derogation. And moving forward to the opening of the hospital, as far as the evidence shows, the government were then still unaware of the agreed ventilation derogation and were not told of the DMA Canyon L8 risk assessment from that year until 2018. In our closing statement, we've set out the errors and missed opportunities by NHS GGC and its contractors and consultants in the period from 2008 to 2015. I don't propose to revisit them all today.
Just a matter of detail. You mentioned the DMA Canyon report. Now, the date of the inspection upon which the risk assessment report was carried out, I think it was the 23rd of April 2015.
It was, Lord, yes.
And migration must have almost been in progress by that.
Migration was almost in progress. The report was handed over to GGC staff soon after it was completed. There was always a very limited amount of evidence about exactly when. We eventually had some emails from Mr. Watson of DMA Canyon, which gave us a date. But the key point is it's clear from the material that the knowledge that the report contained serious concerns about safety was not escalated within the NHS GGC system. And I will come to that in more detail later in my submission. So I don't propose to go through all the different errors and missed opportunities. However, I'm proposing to review 7 questions of particular importance. And I hope my Lord won't mind if I don't list them first and then go to them in turns. Right. So the first one is, what is the relevancy of actions or inactions by the contractors that gave rise to deficiencies in the building systems? And this is a matter that was raised by counsel for Curry and Brown and other counsel in written submissions for call participants from, as it were, the contractor consultant side. Now, without revisiting the submissions of Mr. Connell after the coffee break on Tuesday, it may help to explain why this question is relevant in 3 steps. We have identified a number of decisions or actions by contractors or consultants in the procurement that can be causally connected to the existence of specific defects in the building. It's not for this inquiry to decide where liability or responsibility lies under the various contracts. However, we can, without expressing a view on contractual liability, explain how those decisions or actions are connected to the deficiencies. And that's what we have done. I do wish to pick up on a specific point raised by Ms. McCafferty KC on Wednesday concerning Mr. Hall's sign-off of design drawings for clinical functionality. Ms. McCafferty was correct to note that we did not criticise Mr. Hall for signing off the design drawings, but the design drawing sign-off process, in which he played a significant role, can be criticised. In terms of the reduced scope of Curry and Brown's role from January 2010, Mr. Hall undoubtedly signed off the design drawings for clinical functionality under delegated authority from the board's project manager, Mr. Moyer. Given that he had no technical expertise, was the restriction to clinical functionality clear? In the absence of an express qualification to the approval by Mr. Hall of each drawing, and there was none, Multiplex would very likely assume that Mr. Hall's signature meant that the M&E, the mechanical and electrical technical contents of design drawings, was approved by the board. Ms. White from Nightingale, the architects, appears to have thought this too. It seems members of the NHS GGC project team did not all appreciate that Mr. Hall was only approving drawings for clinical functionality, but was not checking, for example, the required ventilation output. And we can see that in the transcript of Ms. Rath's evidence in Glasgow 3 at column 48. Some thought Mr. Hall was the technical advisor, and that was Ms. MacLeod, who was one of the two project managers for the hospitals, column 92. The next question that I raise is, what was the effect of the lack of a change control process, and how did that oversight happen? In the contract it signed, the Chief Executive, Mr. Calderwood, signed, on the 18th of December 2009, NHS GGC agreed to an agreed ventilation derogation, which reduced the amount of air being supplied to most of the rooms in the hospital to less than half that required by the draft Scottish guidance that the Health Board had decided to apply to the project. There was an earlier decision to remove what was called the maximum temperature variant, and this was issued to contractors on the 20th of July 2009 as part of the competitive dialogue process. The decision to remove the variant can be found in Bundle 43, Volume 6, Document 32.1, page 603. The effect of the removal was to limit the maximum temperature inside the hospital broadly to 26 degrees, rather than the 28 degrees set down in the government guidance. And it made it impossible to achieve 6 air changes per hour in the wards, as required by the same government guidance, and effectively resulted in the agreed ventilation derogation being agreed. That the system couldn't achieve what was set out in the guidance is set out plainly by Brookfield Europe, the contractor, in their tender documents, and it's worth perhaps looking at those. Bundle 18, Volume 1, Document 8, page 311. Now, this is a page from an extensive sequence of documents which make up the tender from Brookfield Europe, which eventually became Multiplex. And this is the 2 pages which set out the ventilation and air treatment design strategy. I'm not proposing to go through it in length. We took a number of witnesses to it. But if we go to the next page, 312, we see within the conclusion, the final paragraph, a reference to the impact of the temperature change. And we discussed that with a number of witnesses. But in our submission, it's clear that Brookfield Europe understood the effect of the maximum temperature variation. It's not immediately clear to us that the board did. You could take that off the screen, please. In our submission, the removal of the maximum temperature variant and the consequential agreed ventilation derogation in the contract were of such significance that they both required to be fully understood and authorised via the governance systems set out by the board for the new Southern General Hospital project. As far as we can see, the project director did not report either change to those he was supposed to be accountable to, i.e. the new South Glasgow's Hospitals and Laboratory Executive Board, which I will refer to as the Executive Board. We know from the papers of that Executive Board and the Performance Group, Review Group, which is a subcommittee of the board, to which it reported, that it was supposed to have a change control system which would enable changes that impact on what the board was to get to receive approval from that Executive Board. The problem is, as far as we can see from the evidence, there was no such system. And so the removal of the maximum temperature variant does not seem to have been discussed, and the agreed ventilation derogation was never approved by those governance structures, including the Executive Board. Many members of the Executive Board gave evidence, and we've set that out in sections 5.3.7 to 5.4.3 of our submissions. It's now clear to us that the Executive Board did not have control over or understanding of what the project director and other members of the project team were doing in the negotiations with the multiplex, or Brookfield Europe, in those final weeks before contract sign. Responsibility must extend beyond those senior members of the project team to the members of the Executive Board, and we've set that out in paragraphs 1662 and 1663 of our closing statement.
When you say closing statement, the
Glasgow 4 one, Lord.
after Glasgow 4. I'll take it, unless you tell me differently,
I'd be obliged, because that's probably the way I will proceed.
that it's Glasgow 4 submission.
Now, it's true that an attempt was made to bring in outside voices to the Executive Board, but in our submissions that was not effective. Mr. Baxter, as the representative of the Scottish Government Capital Investment Group, had a relatively limited role. Partnerships UK were also represented in the board and could have been an important voice calling for assurance and rigorous project management, but lack of surviving documentation means we will never know whether Partnerships UK did raise these issues or remained silent. The conclusion that the attempt to bring in outside voices was not effective informs our proposed recommendation at paragraph 1877 of our closing statement, following Glasgow 4, that the Scottish Government should instruct specialist legal advice and representation in all major healthcare projects during the period between the approval of the outline business case and contract signature. Mr. Connell addressed this in some detail on Tuesday. My third issue or question is, how did the specialist ventilation wards end up with inadequate ventilation systems? So a key issue is why it was that the 4 wards with specialist ventilation needs, including the Schiehallion unit in Ward 2A and the adult BMT unit in Ward 4B in the Tower, ended up with 3 air changes per hour outside lobbied isolation rooms, when the guidance said they should have had 10. We've covered this in detail in section 7.3 of our closing statement and discussed the issues with the clinical output specifications, the use of ADB codes, whether the design team at TUE should have asked more questions or realised that these were specialist wards. But in our submission, serious consideration should also be given to 2 factors that can be linked to this failure: the weakness of the project team and the stand down of the Curry and Brown technical team. In our submission, these 2 factors made it inevitable that NHS GDC would not spot the problems before the wards were built and opened. Firstly, the project team did not have the skills to deliver the hospital that was expected. We've covered this in significant detail in section 5.6.2 of our closing statement, and also in chapter 8 in paragraphs 1506 and 1571 to 1575. NHS GDC senior managers appointed personnel to its project team who had little or no experience of a project of this size and scale. Secondly, on the 18th of January 2010, a decision was made to do without technical advisors, including mechanical and electrical engineering consultants. The responsibility must lie with NHS GDC and its project team. We have the letter informing Curry and Brown of the decision, and we've described it in some detail in paragraphs 614 and 615 of our closing statement. But it's interesting that the high-level information pack issued the following month to those who were bidding for the role of NEC3 supervisor still identified the Curry and Brown technical team as being in post. See paragraph 784. And many members of the project team, including both project managers of the Adult and Children's Hospital, did not appear to realise the change. The keeping of technical advisors was essential to getting the hospital the board wanted. My fourth question is, what was the impact of the limited involvement of the Infection Prevention Control Team in the new Southern General project? In our submission, the lack of involvement of the IPC team in the project had a significant impact. Firstly, two specific oversights in 2009 need to be considered. The first is the key meeting on the 18th of May 2009, chaired by the then Infection Control Manager, at which specialist ventilation requirements for the adult hospital were defined. These were not incorporated into the employer's requirements and into the contract. See section 5.3.6 of our closing statement. Had they been, not all the isolation rooms would have been built as unsuitable positive pressure ventilated lobby rooms. Some responsibility of this oversight must lie with the project director, but also with the infection control manager who chaired the meeting. Secondly, there was no infection control nurse seconded to the project team at the point the agreed ventilation derogation was accepted. The then IPC nurse consultant...
Matter of detail, given what we heard about the infection prevention and control nurse who was later seconded, would the absence of an equivalent person have made a difference?
Well, the problem with that, my lord, is that the previous infection control nurse who was seconded, which was Miss Rankin, had a higher level of skill.
Yes. Right.
I recollect the evidence of Miss McCluskey, who was the senior nurse seconded to the team, when the discussion was had with her about how many people would be required to be in a single room, which we've placed to the discussion about the reduction in air supply to rooms. At that point, if there'd been an infection control nurse in that conversation, we would like to hope that there would at least been a possibility of it being escalated upwards.
Right.
Because it's worth remembering at this point, 2009, the board did have access to an experienced clinician, Dr. Hood, who did later give advice the following year on the renal dialysis room. So there was a source of advice. The question was whether they would get it.
Right. So in thinking about that point, I should take Miss Rankin as the notional but absent nurse.
I think so, because I think there's an issue about whether Miss Stewart had the experience at the time that she took the role. But Miss Rankin had left in November, so there's a short gap during which the derogation is agreed when there's no there's no infection control nurse, and that's the moment when the conversation is had about the number of people who can be in the room, or will be in the room rather. Now, the then IPC nurse consultant or associate director, who's now director of IPC, explains in her, I think it's her consequential witness statement for the Glasgow 4 Part 2 hearing, that when Miss Rankin left, she initiated a recruitment process. But that meant that the project team was without IPC support at a key time, whilst the role was filled. And in our submission, that contributed to the lack of IPC input into that decision on the agreed ventilation derogation. The sort of higher level point, however, which we develop in section 6.4 of our submissions, is the importance of the HI Scribe system, which is the Scottish Government's healthcare associated infections system for controlling risk in the built environment. We have found nothing more than an attempted stage 2 HI Scribe for the project, and it can only be described as entirely inadequate. We've covered it in some detail in section 5.6.7 and paragraph 672 to 677. We didn't find any other HI scribes. Whilst HI Scribe was then relatively new, the novelty of the scheme might explain if the process had been done poorly, but not that it was effectively, for large parts of the project, not done at all. Consideration needs to be given to where responsibility lies for not following HI Scribe. Now, the principal responsibility must lie with the project director and the two senior responsible owners for the new Southern General project, Ms. Byrne and Mr. Calderwood. Although it must be recognised that on one occasion Mr. Calderwood did ask at a project meeting whether HI Scribe had been carried out, and we set that out in paragraph 667 of our closing statement. It's striking that in their statements for Glasgow 4 Part 2, the then IPC Nurse Consultant Associate Director, now Director of IPC, and the then lead ICD, explained that they only became aware of the Stage 2 HIS scribe because of evidence to the inquiry. And we've covered that in paragraph 675.
When you say only became aware of stage 2, what do you mean?
Well, we asked them effectively, what do you think of the Stage 2 HIS scribe? We gave them a copy and we asked them using it. And both of them responded that they weren't aware of the document until we put it to them.
Right, so they weren't aware of the document in the sense of HFN 30?
No, they weren't aware of the Stage 2 document that the
right, which
ICN...
is the pro forma with answers.
The pro forma with very, very limited answers. We put that to them after the author gave evidence and asked them to comment on it. And as part of their answer, they both indicated that they only first saw it when we put it to them. Now, this must mean that neither of them looked for any of the HIS scribes, even after the hospital opened and concerns were raised about the ventilation systems in wards 2A and 4B. Now, it should be noted that the lead ICD in question left the board in 2016, but the director of IPC has been in post and closely involved in the issues around Queen Elizabeth ever since. In our submission, the reasonable but troubling conclusion is that they were simply not interested in this important process as applied to the project. Now, it's fair to say that the version of HIS scribe that was in force in 2009 does not formally allocate responsibility for applying its principles to the IPC management team. But these are the people in the board who best know the importance of IPC. They were the available experts. Some responsibility for the failure to follow HIS scribe must therefore be placed at the door of the infection prevention control management team at the time. Now, the fifth question is, where does responsibility lie for water safety failures? And Lord touched on this in the question a moment ago. Now, in Glasgow 4 Part 1, we heard evidence of how the hospital water system was filmed possibly 18 months before the hospital opened. And I won't revisit in detail the failures to respond promptly to the 2015 and 2017 DMA Canyon L8 risk assessment. But in our submission, those events must be seen in the context of the extent to which NHS Greater Glasgow and Clyde comply with its own water safety systems policy, which can be found, the version that was in force at the time when the hospital opened, in Bundle 27, Volume 2, Document 1, page 5. The board now appears to accept that the resourcing for building maintenance at the time of the opening was inadequate. But we go further. When the hospital opened, there was no water safety plan or written scheme for the site, and the necessary authorised persons water and authorising engineer water had not been appointed. Had those documents been produced or the persons appointed, there is every reason to think that the water system would have been better managed, and the biofilm, microbial proliferation, or widespread contamination found at the start of the water incident would not have grown to the extent it did. And we address these issues in detail in paragraphs 1261 to 1268 of our most recent closing statement and section 6.1 of our closing statement from Glasgow 3. Mr. Calderwood's lack of understanding for his responsibilities as duty holder for water was striking, but responsibility for these failures also falls on other shoulders, and by following what's in the water safety systems policy, including the Director of Facilities as designated person water, and the infection control manager as designated person pseudonomus in those roles, but also as co-chairs of the board water safety group, and also the general manager estates, later head of corporate estates. The sixth question is, was there a lack of questioning by senior staff? As we noted in paragraph 76 of our closing statement, it was a key conclusion of the Vale of Leven Hospital inquiry that in dealing with the issues that prompted that inquiry, many NHS GGC managers failed in one of the fundamental aspects of management, namely to ask questions. The key paragraph in chapter 1 of that report should be revisited. I wonder if we can put it on the screen. Bundle 51, Volume 1, Document 2, Chapter 1, page 238. So this is the section, my lord, headed management. If we can zoom in a little bit. And so the first part I've already quoted for, the importance.
Yes.
The monitors keep flashing on and off. There we are. The importance of questioning. It was surprising how managers at different levels within an organisation like NHS GDC failed in one of the most fundamental aspects of management, namely to ask questions. Now, this text was published in 2014 when the Vale of Leven report reported. And then there's a discussion of culture. The culture, quite apart from a number of individual failures to investigate and be aware of what was actually happening at the Vale of Leven Hospital, it became apparent that there was systemic failure. Ultimately, this can only be described as a management culture that relied upon being told of problems rather than actively seeking assurance about what was in fact happening. To take an example from the evidence, a manager who has a responsibility to ensure the delivery of high-quality care cannot fulfill that duty simply by relying on being told when a specific problem emerges and reacting to the problem. Some managers with responsibilities for the Vale of Leven Hospital also had responsibilities for other hospitals operated by NHS GDC. But the inquiry's focus, of course, was only on the Vale of Leven Hospital, and in consequence I cannot comment on their broader performance. Nor do I know how prevalent this style of management would be generally within NHS Scotland. Nevertheless, the clear lesson to be learned is that an important aspect of management is to be proactive and obtain assurance that systems and personnel are functioning effectively. Now, in our submission, my Lord, that conclusion was made nearly more than a decade ago by Lord Maclean, and it applies almost word for word to the experiences, the evidence that we've seen, and the conclusions we can reach. Particularly as the way we've described it and what's been described to us is exception reporting. The idea that you expect your direct reports to report exceptions from successful performance to you, and therefore assume that everything else is good. And in my submission, one can take the evidence of a number of witnesses and read that text and see the same issues reflected in their evidence of their conduct in 15, 16, 17, 18, and maybe even later.
Certainly, I think you put that specifically to Mr. Calderwood.
We did. Yeah. I don't think we put it to some of the other managers, but I think it's a fair reflection on their evidence, looking at it in context. I should just say at this point probably that it's worth emphasizing that we acknowledge that people make mistakes, that an individual mistake is something that is unfortunate and needs to be learnt from, but probably shouldn't, unless it's a particularly serious one, be one that will be picked up by a public inquiry. It's the repeated mistakes and the systemic issue of them that concerns us more, but I'll return to that later. In our submission, these observations apply just as much to the procurement of the Queen Elizabeth and the GDC response to its flaws as they did to the Vale of Leven. To some extent, the issues facing this inquiry are the same as faced as the Vale of Leven inquiry. In paragraphs 12.2 and 12.3 of their closing statement, GDC do appear to accept that criticism of this sort can be applied to the procurement of the hospital. But from reading this section, I gain the impression that the concession only runs to an undefined point after handover. In our submission, this lack of question.
This is 12.2.
12.2 particularly. So a pattern emerges, say the Health Board, from the evidence of lack of scrutiny and challenge in respect of project governance on behalf of NHS GDC. Many witnesses consider that responsibility for particular issues sat elsewhere, leading to no one taking responsibility for those issues. No individual acted in bad faith. I'm not sure that's the test. It was simply a failure to allocate and adequately specify roles and ensure that reporting lines were in place. These issues would not occur in the present NHS GDC. And then 12.3, this issue was particularly acute when it came to receiving advice on the design of the hospital. There was little expertise from the board to cope with a project this magnitude. The board was accepting what it was told during the design and construction phase. It was reliant on the technical team and did not properly interrogate what it was told. The project team operated on assumptions that others would take responsibility. This all manifested in the absence of full commissioning and validation. At handover, authorised persons were not in place. When they were identified, they required significant training. The board was poorly advised, but lacked the expertise to challenge that advice. The board is now in an entirely different place. Now,
that includes the assertion that the board was reliant on the technical team, and we're talking about the design approval phase, and there was no technical team in place.
yeah, I read that as the board was reliant on the contractor's technical team.
Right.
But
Fair
and
enough.
that's consistent with the evidence from the project director, who feels that in some unclear way he received an instruction not to challenge technical matters with the contractor, though we were never really able to pin down if that instruction was given or where it came from. In my submission, if we go back to the previous page from the Vale of Leven, we notice that Lord Maclean observes that his focus was on the Vale of Leven Hospital, and in consequence, I cannot comment on their broader performance. Well, he's describing events in 2008, 2009, and 2010 in the Vale of Leven, and this concession applies to events in 2008, 2009, 2011 in the New Southern General Hospital. To some extent, there is a corroboration here. He's seeing similar problems in a different part of the same organisation at the same time. Now, if we take that off the screen, in many ways, we have already discussed the lack of questioning extended to the members of the IPC management team, the Board Water Safety Group. And as I'll come and develop later, extends, possibly in the case of the IPC senior management team, to the present day. Key staff, including people whose actions were subject to comment in the Vale of Leven Hospital Inquiry Report, did not ask questions about their new hospital, even when clear deficiencies were brought to their attention by many people in 2015. At best, these public services servants focused on the task in front of them, or the reports from their direct reports. They were not prepared to ask questions. Which brings me to the question of whether this is the seventh of my seven. Was there a failure to act in June 2015? By the end of June 2015, it was clear to anyone who cared to listen that there were flaws in the ventilation system of two key specialist wards, Ward 2A and 4B. Other issues took time to emerge as understanding developed, but it's not correct to describe the emergence of problems within those two wards as gradual, evolving, or iterative. The return to the Beatson of the Regional Bone Marrow Treatment Unit after 5 weeks due to concerns over the ventilation system placed the relevant managers and the board on notice that there were flaws with the ventilation system of their building. In our submission, it's a complete abrogation of responsibility to fail to investigate the whole system and its procurement at that point. The letters sent by Dr. Peters and Dr. Inkster at the start of July 2015, which can be found in Bundle 14, Volume 1, Document 26, at pages 414 and 420, resigning, or as the ICM put it, demitting their sessions as infection control doctors, was a red flag that required action. The then medical director did order an investigation into culture within the IPC team in response, and that investigation ultimately resulted in the appointment of Dr. Cruikshank and an improvement in relations between colleagues. But there was no comprehensive investigation into the safety of the building. Had such an investigation been carried out in 2015, 4 things might have happened. The extent to which the agreed ventilation derogation applied to different parts of the hospital could well have been discovered in 2015 and its implications understood. The decision to make the isolation rooms positive pressure ventilated lobby rooms, which are not suitable for highly infectious or immunocompromised patients, would have been discovered, and the programme to rectify them would have begun earlier. It would have been realised that in effect no part of the HI Scrape system had been applied to the construction of the hospital. I appreciate there was a stage 2, but it's entirely unsatisfactory. In the general climate of investigation there would have been a good opportunity to understand the weaknesses of the water system, and that would have been a matter of 3 months after the DMA Canyon report was handed over. Now, there was an attempt the following year when Mr. Parry reported on the 26th of May 2016, which is an email at Bundle 20, Document 68, page 1495, of the existence of the agreed ventilation derogation. If you remember, my lord, he attached the ZBP ventilation strategy document to his email, which set out the justification for that derogation, such as it was. And there was then an exchange of emails that resulted in Mr. Seaborne's email of 23rd of June 2016, which we come to know as "We are where we plan to be." And that's a Bundle 12, Document 104, page 813. But Mr. Seaborne's email raises far more questions than it answered, and should also have prompted an investigation. Stepping forward a further year, it's also worth noting that the evidence of the then Chief Executive, Ms. Grant, was that it was the SBAR of the 3rd October 2017 by Dr. Redding and her colleagues that resulted in her, the Chief Executive, and the then Chair, Professor Brown, learning about the ventilation issues in the hospital. They didn't know until then that it took a whistleblower.
So we're talking about October 2017.
We are.
Right.
Now, of course, Ms. Grant had arrived in, I can't be sure whether it's March or April, but the earlier part of the year.
Certainly in sometime in that year.
Yes, and Professor Brown had been in post since the first month of 16. But it appears to be the case that it took the SBAR, the whistleblower, by Dr. Redding and her two colleagues, to cause the Chair and the Chief Executive to learn about the problems that had been reported in 2015. In my submission, that speaks to a repeated lack of a desire to ask questions by those who reported to Ms. Grant that amounts, in our submission, to willful blindness. Now, this inquiry has had to reconstruct a procurement process that took place more than 15 years ago. In our submission, it's reasonable to conclude that an investigation carried out just 6 or 7 years after the event being the signing of the contract, and only a couple of years after the opening of the hospital, would have been more likely to produce conclusions faster and more efficiently, because the second project director was then still employed by NHS GDC. More documents and materials would have been made available. Parry and Brown were available to answer questions. Multiplex was still on site, and the final completion certificate had yet to be issued. Memories would have been fresher. The contrast with the rapid response of NHS Lothian and its decision to report concerns about the ventilation in the Edinburgh Hospital this inquiry has been looking into, to the Scottish Government, almost as soon as they came to light, is striking. Now, on Wednesday, Crawford KC for the Scottish Government highlighted the NHS Lothian response. If I understood, the point being made was the oversight systems now exist to ensure that issues like this are highlighted and addressed. And our response has to be that that submission is only partially effective. The Glasgow hearings have been considering the situation in contrast with Lothian, where a health board did not ask questions, did not disclose to ministers, and did not seek help, and arguably continues to do some of those things even now. Our submission is that oversight systems and guidance currently in place are not set up to deal with such a recalcitrant health board. So to summarise those 7 issues or questions, a broad summary of the answers to these questions is that the response of NHS GDC, its managers and directors, to defects in the water and ventilation system of the hospital was inadequate due to lack of effective governance, lack of use of technical advisors, and a significant and long-standing aversion to asking questions. I'm proposing now to move on to my second question: what harm was caused by the deficient features of the building? I must start this section by acknowledging the real harm and distress caused to patients, and in the case of the children, their parents, in the case of the adults, their families, in the Queen Elizabeth University Hospital and the Royal Hospital of Children in the years after the hospital opened in June 2015. This impact is powerfully summarised in their statements and in the submissions produced and made by my learned friends, Ms. Love KC and Ms. Connolly. And I don't propose to revisit them. I don't think I can do justice to the extent of the impact by picking individual remarks or individual sections from, with one exception, from statements. But we will all listen to them, and my Lord's heard them all. In our closing statement, we described that the widespread contamination or biofilm growth or microbial proliferation found in the water system in the early months of 2018, found by NHS GGC staff. Now, in our submission, there were a material number of bloodstream infections amongst the patients in the Schiehallion unit who acquired bloodstream infections linked to that water. We cannot say exactly how many patients were affected, but in our submission, it's important to note that Dr. Drumwright's later work, when she had access to all the data, is consistent with it being around a third of cases. That, of course, is broadly the same as the conclusions of the case notes review. NHS GGC now accepts that there was an exceedance in the rate of environmentally relevant bloodstream infections amongst paediatric hemato-oncology patients in the Royal Hospital for Children in the period 2016 to 2020, with a decrease when remedial measures began to be put in place in 2018. And that is more likely than not the material proportion of these additional BSI had a connection to the state of the water system. And I think it's fair to say that a lot of the effort of the inquiry team has been put into investigating that issue. This concession covers the period prior to 2018 when Dr. Peters and others were raising concerns about the availability of water testing results and the operation of the IPC team, the period of the water incident in Ward 2A in 2018 up to decant, and the period in 2019 when Dr. Inkster was investigating gram-negative infections in Ward 6A as chair of its IMT. I want to make a few specific observations on ventilation. The evidence shows that the ventilation system of the hospital was not validated against any standard before opening. On Tuesday, you asked Mr. Gray if validation had now been done, and he said he would take instructions, but we'd be surprised if it had not been done. Mr. Steele's evidence, if we look at column 75 of this transcript, shows that validation had only been carried out in, quote, selected wards across a number of different floors, level 4, level 6, level 5, level 7. In the last couple of days, we've been just producing a list. Ward 2A, 2B was validated by Sutton Service International after reconstruction in February 2022. And that document is Bundle 52, Volume 10, Document 45, page 225. Ward 4B was validated in November 2017 by H&V, and their ventilation report of the 6th to the 10th of November 2017 is referred to by Mr. Poplett in his first ventilation report. That's Bundle 21, paragraph 10.8, page 571. Ward 4C was verified rather than validated on the 16th and 17th January 2020 by Correct Air Solutions Scotland Limited, but was found to be deficient for immunocompromised patients. Bennett report. That's Mr. Bennett's report, Bundle 21, paragraph 8.27, pages 689 and 690. I should say that subsequent to that, there was a risk assessment done, which we discussed in our submission. Critical care, HDU and ICU, were verified in 2019 and 2020, but not validated. Critical care isolation rooms were verified in 2022. Mr. Poplett's report, Bundle 21, paragraphs 10.4 to 10.6, pages 570 to 571. And some rooms, we know in PICU, that's Paediatric Intensive Care Unit, were verified by Correct Air Solutions Scotland Limited. And we have that in Mr. Poplett's report, Bundle 21, paragraph 10.50, page 579. Now, it may be that Professor Steele has confused validation and verification, but the key point to make today is that the whole hospital ventilation system has not been validated. The general wards have not been validated. It's most concerning that's still not been done. However, in respect of actual harm caused by deficient features of the ventilation system, the question is harder to answer. We accept NHS GDC's view that a non-compliant ventilation system does not mean it's necessarily less safe. And I think that was Mr. Poplett's position as well. However, the point we make is that a reduction from 6 air changes an hour to 2.5 to 3 air changes an hour does increase the risk of for highly immunocompromised patients who are placed in general ward standard rooms. And this accords with Professor Humphrey's view early on in the inquiry. So that's Professor Hilary Humphreys, 12th of May 2022, column 52. And it's also important to recognise, as Mr. Bennett and others did, that there were no HEPA filters in the general rooms, meaning that harmful fungal spores, such as aspergillus, will pose a risk to immunocompromised patients in general rooms. And if the air change in general rooms is reduced from 6 air changes per hour, then plainly that must increase the risk to immunocompromised patients to some extent. And given the devastating consequences of such an infection for those highly immunocompromised patients, then in my submission that risk is increased to a material degree. Beyond saying that, I don't propose to repeat our assessment of what risks remain, because we've set that out in detail in our closing statement. However, in light of the change of position by the Health Board and its continued insistence that in all respects the hospital is now safe, I should revisit one issue, and that is the importance of risk assessment. Now, it's difficult for a public inquiry to do anything other than to ask for a proper assessment of risk. That, after all, is at the heart of risk management. Now, I agree with Mr. Gray when he said on Tuesday afternoon that risk management has to be robust in order to demonstrate safety. Whilst some attempt has been made to consider the risks arising from inadequacies in the ventilation system of some specialist ventilation wards, the Health Board have never attempted to formally assess the risks arising from the fact that 1,300 rooms in the hospital are supplied with air at a rate half of that provided for in the Scottish Government Technical Memorandum that the GDC decided would apply to the project and is now in force. It should also be appreciated that the supply of air to these rooms is such that having more than 5 persons in each room drops the rate of supply per person below that provided for in the building regulations for all buildings with mechanical ventilation. Now, we've addressed this at length in our closing statement at paragraphs 1182 and 1183, 1751, 1898 and 1899. Now, NHS GDC, my lord, have pledged to implement all your final recommendations. Now, we proposed 2 recommendations on the need of carrying out a risk assessment of these wards, and that's at paragraphs 1898 and 1899. I hope it's not presumptuous to point out that it will take the inquiry a few more months to finalise its report. It's therefore open to NHS GDC to take steps now to carry out such a robust risk assessment of the ventilation to the general wards and these rooms without waiting for my lord's final report. The final section of my submission, rather longer than the other 2, is the question 3. How can what took place be prevented from happening again? Now,
I wonder structure. I think we're moving away from the procurement process and the consequence of the procurement process. Now, one of the points you made this morning is that the inquiry had to reconstruct the procurement process. So it wasn't really just a question of going to GDC and saying, tell us about it. It was, you were looking at events which had happened before 2015, and you had information from a number of sources. Now, it occurs to me that yesterday I was guilty of a very lazy and inappropriate remark in discussion with Mr. Love. And this arose, I think, from I think the discussion we're having at that point was relating to a point that was made by GDC in paragraph 6.14 of their closing statement.
Yes, Lord.
Now, first point, what we see set out in GDC's the only closing statement to which they would wish me to have regard, or that's not fair, the only closing statement which they put forward to the inquiry at this stage is that they include the sentence, pressure was applied to open the hospital on time and on budget, and it is now clear that the hospital opened too early. It was not ready. Now, I didn't ask Mr. Gray about this. We do not find an explanation of what the pressure was, or what he has in mind by pressure, and I didn't ask him as to why it was clear that the hospital opened too early. Now, where I was lazy and quite frankly simply wrong in my exchange with Mr. Love was to say, well, that is what GDC say, therefore they're in the best place to say it. Now, that I think is wrong, because whether or not GDC are in a good position to say any particular thing depends on the state of institutional knowledge at a particular point in time. And going back to what you say about the inquiry having to reconstruct the procurement process, if the inquiry had to do this, then it may be that GDC, by the time we get to 2022, 2023, are not in a position to certainly not in a position to draw on any information which is not available to the inquiry. So I have to recognize a laziness of thinking on my part. Now, having said that by way of preliminary, I do not recollect counsel to the inquiry making anything of the hospital opening too early. Now, am I right about that?
Yes, my lord. But first it's worth saying that, as far as I can recollect, beyond one particular aspect of pressure, there was no evidence from the senior GDC people involved in opening the hospital, from Dr. Armstrong down and Mr. Calderwood, about pressure either from them or from anyone else. The aspect that did exist, of course, was that it's a massively complicated task, merging multiple hospital sites into one site. And probably the best witness who explained that was Dr. Stewart, who'd been the deputy medical director, and he, I think, was responsible for acute services at the time of opening, and described in his statement, albeit we didn't ask him a lot about it in oral evidence, the complexities of that task. And so there was a massive choreography to move everybody into the hospital at the right times, the right services are available. And I certainly have recollection of when one reads Acute Infection Control Committee or Board Infection Control meeting minutes, or the IPC senior management team, you get the sense of that from presentations being made and discussions and things. So there's pressure in the sense that it would be a good idea to meet the target, because otherwise it will be difficult for everybody. There will be failures. But we didn't detect in the evidence pressure in the sense of open it earlier than was planned. And then turning to my lord's question, from my recollection of Professor Steele's approach, he didn't seem to be, I mean, he was quite candid about that. He didn't have information about things that happened a long time before he took over. And as director of estates. And similarly, although the independent review didn't have access to GGC's contract documents around the procurement because of the litigation, that was the reason that was given. So nobody, other than this idea of we really ought to get this project delivered on time because that's what you should do, talked to us about pressure, and GGC certainly didn't advance that until that sentence. So that's probably the reason it sort of stands out as rather surprising. I mean, it could be just internal pressure, because internal pressure to meet a deadline is not really that surprising. I mean, we said in our submission that it's to a degree commendable that the project was delivered on time and on budget. So that may be what people are talking about, but it's not something that's been advanced as anything more than that desire to get delivered on time.
Now, what evidence about the hospital opening too early and it not being ready do we have? We had Mr. Powery, I think, describing many subcontractors on site,
yes,
carrying out what I took to be snagging work.
There certainly was that. And of course, there was a small amount of work that happened after the move when issues like the one that's described in that paragraph of the HEPA filtration filters not being in housings arose. There were issues around holes around lights fittings, I seem to recollect, in certain wards.
In relation to the HEPA filters, which, according to this paragraph, is an obvious example, am I right in thinking that Multiplex's position is they were told to emit?
Yes, there's a document.
I mean, is that a correct recollection on my part? Or?
Whether it's contractually correct, I can't say, but there is a document prepared by ZBP in 12 or 13 which lists what's to go in the ventilation of the isolation rooms in Ward 2A, and it's housings only. But we've never been able to work out from the available documentation whether that's, as it were, internal within the contractor side or something that the board has approved. And this is the problem with reconstructing this material, because as we've explained in our closing submission, certain witnesses are not available for that reasons of health and other more serious concerns. And the contract itself is, I mean, I freely confess, I'm not a commercial construction lawyer. That's why I'm grateful for the assistance I've always had from Mr. Connell in that respect and the solicitor of the inquiry. But the way that the agreed ventilation derogation was in the M&E clarification log took us a long time to work through. And so one of the difficulties of the inquiry is trying to reconstruct a series of negotiations that happened a decade ago. And it's all very well for witnesses on the contractual commercial side to say, if you just look in the log, it's all clear. But you've got to find the log. You've got to know what the log is. You've got to work out how it fits into the contractual documentation. So we, I think, found paragraph 6.14 as somewhat of a surprise, because although there was a pressure to open time on time because of the obvious consequences, we'd not heard anything else in our investigations.
Right. Do we have any evidence of how that, I mean, let's assume for the moment that it, well, I'm not quite sure what one can assume on the basis of these rather broad brush statements, but does this link in with deficiencies in ventilation from your perspective, or deficiencies in water system from your perspective?
So there's 2 points I think to make. Firstly, it's worth remembering that the ventilation system wasn't validated.
Yeah.
But it wasn't validated because they hadn't got around to it. It wasn't validated because they didn't know they had to validate. So I'm not sure a few extra months would have caused validation to happen. You have to understand, by reading the necessary guidance and having access to technical people, that validation is required. And that seems to be missing. The second problem is that the bigger problems with the hospital ventilation system, that flow from the agreed ventilation derogation or from the decision to only fit positive pressure ventilated lobby rooms are not small issues. In fact, they're very hard to fix. And so had the builders just continued for a few more weeks, that issue wouldn't have been fixed. It had to be spotted. And one of the things that's striking about the correspondence that Dr. Peters has with various people in 15 is that she's probably at the very point of the realization in respect of the pediatric wards issues, is that her emergency is growing. Because it's not like she's supplied with a list of deficiencies. She goes around and says, well, where's the pressure gauges? Why is there a hole in the ceiling? It's a gradual process that crystallizes by the end of June. But it's the idea that a few more weeks would have fixed these problems forgets that no one understood these problems existed.
Anything else you want to say on that?
Not on that, thank you, Lord. Right. And what I'm proposing to do is to move on to this third question. So what I propose to do, and I'm grateful to him for this, is to lift something from Professor Cutterhay's final witness statement. Well, actually, it isn't the final one. It's the final one when I was drafting this. The one produced for the Glasgow 4 Part 2 hearing, and it can be found in Volume 3 for the hearing of the 16th September of this year. It's document 6. It's from page 242. And he describes what his statement as a father's plea for governance that protects the vulnerable. And he structured his statement under 5 headings. And I rather felt the headings were useful for, I hope you won't take this badly, for a broader analysis of the issue. The headings are the illusion of safety, the silence of broken systems, the cost of complacency, a demand for accountability, leadership accountability, the missing link. And what I propose to do is to borrow those headings and use them to look at the questions inherent in them to help the inquiry reach conclusions on its remit in terms of reference. So let's start with the illusion of safety. Hospitals should be safe. Risks should be understood and managed. Patients should, in broad terms, be able to consent to the risks they run in treatment. Those who run hospitals should strive for safety. They may never achieve the avoidance of all risks. That is to some extent impossible. But the expectation of patients, their families, the public, and the clinicians who treat the patients, is that those who provide the equipment in the buildings will act to prevent the buildings causing infections. Now, the clear message that I took from the patients and families is the last thing they imagined is the hospital they and their loved ones attended was exposing them to water that was contaminated with microorganisms that should not be there, or should not be there in those proportions, and which made them sick, or failed to protect them from airborne microorganisms. The Queen Elizabeth University Hospital and the Royal Hospital for Children looked state-of-the-art, it looked new. But we now know, and it's long been suspected, that to some extent that was an illusion. So the next issue heading was the silence of both broken systems. Now, I think I've discussed these to a great degree already. Not only was there a failure of the systems within NHS GDC that procured and commissioned the hospital from 2009 to 2015, but the management systems remained broken from 15 onwards, and the board took too long to discover the deficiencies of the water and ventilation systems for fundamentally the same reasons that had undermined their ability to procure and commission the hospital. And they're the same reasons we see in the Vale of Leaden report. And support for this analysis can be found in section 9.10.2 of our Glasgow 4 closing statement, and the parts of our closing statement following Glasgow 3, which we identify in that section. I don't propose to walk through the many occasions in which clinicians, principally Dr. Peters and Dr. Inkster, raised concerns about patient safety in the Queen Elizabeth and were ignored, rebuffed, or had their views minimised. But I note there's now no substantive challenge to that analysis in the most recent GDC closing statement. However, there's one particular issue I do want to look at, because I think it helps us understand the events of 2019, and that is the idea of an executive control group. In our submission, the initial response to the water incident in March 2018 was collegiate and effective. That may have had much to do with the work of Dr. Inkster as the chair of the IMT. However, there was a failure to create an effective system to which the chair of the IMT could be accountable and to whom she could report. This was the idea of the executive control group, discussed at paragraphs 951 and 1683 of our closing statement. An idea I do recollect approved of by Dr. Mumford and Miss Dempster when they gave evidence at the end of Glasgow 3. My lord will have noted at the time, when we asked questions and in our submissions, that we have had concerns about the way in which the medical director, Miss Grant, the chief executive, and other NHS managers involved in the water review group that approved the decant on the 18th September 2018, seemed to initially suggest that responsibility for that decision fell on Dr. Inkster as chair of the IMT. The decision was clearly one for the executive leadership of the board, given the widespread impact on different patient groups across the hospital and the board services, and yet repeated attempts were made to avoid taking responsibility for it. In our submission, the failure to set out clear lines of authority and responsibility, separating the tactical response to the incident by the chair of the IMT from the whole board response when wards were to be closed or decanted, was a factor in how matters came to a head in August 19. To some extent, we see that lack of structure in the brief decant to the clinical decision unit in early 19, when there's an informal huddle, when Miss Grant comes over to discuss the merits of the decision. In contrast with the position advanced by the board, it's our submission that in August 2019, NHS GDC managers and directors were unhappy with Dr. Inkster continuing to investigate the hypothesis that there were still infections linked to the building systems. That there was an excess of infections, albeit a reducing one at that point, has now been confirmed by expert evidence, which the board now accepts. This contradicts the view reached by some of the board's witnesses at the time that there was no excess of infections in August 19. And this is the very period at which Dr. Armstrong, the medical director, argued in her evidence that Dr. Inkster and Dr. Peters were putting their professional interests ahead of the patients by talking about excess infections. And you find that in transcript of Dr. Armstrong, columns 227 to 230. And in our submission, now we have the epidemiology. Those concerns have no basis. There was an issue that required to be examined. The inquiry should conclude that the removal of Dr. Inkster as IMT chair in August 19 was a clear case of an organisation that wanted to shut down debate rather than follow the science. Now, at this point, it's probably make a slight aside and make a response to an observation about recommendations that arose from the submissions on behalf of Scottish ministers on Wednesday by Ms. Crawford about Section 51 and Schedule 5 of the Scotland Act and 1998 and the devolution settlement and who the Health Board can employ, which was said to be relevant to our recommendations, proposed recommendations at paragraph 1702. And that was that, in broad terms, the submission of the ministers be provided with the power to, in extremis, transfer the running of a health board to commissioners or replace the whole board or parts of the board. And in our submission, this can be done by a limited development of the powers in section 77 and 78 of the National Health Service Scotland Act, 1978.
Could you, my fault, Mr. McIntosh, could you maybe take a step back? We've
leapt.
You've taken us to August of 2019 and Dr. Armstrong's evidence, and then you've moved, I think, too quickly for me.
Yeah, I appreciate that more.
To a matter of statutory competence raised by Ms. Crawford.
Certainly. So the reason that I made the leap, perhaps I should have explained it, is that if we think about the heading we were starting on, the silence of broken systems that Professor Cudahy had chosen, which I borrowed. We've discussed the brokenness of the systems in the procurement at length, and I don't propose to revisit them. And we've discussed the problems of questions not being asked about the building in 15, 16, 17. And another aspect of a broken system is the way that the board's management, as it were, managed Dr. Inkster and her IMT. That was clearly a very intensive, stressful period for everyone, and I'll come to what that might mean in a moment. But the board had to deal with the consequences of having such a series of significant and publicly notable incidents. So our submission is that, firstly, there should have been some form of executive control group, and not having it meant that the tension between individuals in the IMT and also between the idea that we should investigate because that's where the data was going from Dr. Inkster, or the idea that because the chlorine dioxide system was fitted, the water was fine now, from perhaps others, that could have been better resolved if, as I think Dr. Mumford said in her expert evidence in November 2024, there'd been a clear method by which the senior manager of the board could take the advice and then they make the decision. So whether it's to partially close the ward to new admissions or reopen the ward, the board executive needed to make the decisions and take responsibility for it, but to do so on the advice of Dr. Inkster, rather than putting all the pressure on her to stop her investigating.
Right. So when you talk about board executive, you mean the executive directive?
I mean the executive directors, because I got the impression from the evidence of Professor Steele, the medical director, Dr. Armstrong, and others, that there was they would go back to their offices from the IMT, or people would come to them from the IMT and report about what happened in the IMT. So one gets the impression that Dr. Inkster is dealing with the incident, she's investigating it sort of live in the IMT. This is being reported back to senior people, and they're worrying about it. Perhaps they're right to worry about it. But what they should do is hear the advice and then make a decision, not do what in our submission they then do, which is to say, well, actually, the personal relationships are broken down, and close her down. Because there's a striking section in Ms. Watt's submission that deals with a particular member of staff who describes the finding of, I always get this microorganism wrong, Elizabeth Kingia miracolia, which was initially identified on the space station. A witness to
or has been.
I don't know, but it doesn't just exist on space stations, is the point that I think is being made. But the impression is gained from that particular non-technical witness that that's what they thought Dr. Inkster was saying, that this was somehow a space bug that turned up in their ward. And I think that just illustrates the idea that there's a technical discussion to have and there's an executive decision to have. Mm-hmm. And the two of them need to be separate. And that is what Dr. Mumford and Ms. Dempster talked about, I think, from some experience and knowledge south of the border, in their evidence over those 2 days in November 24. Now, the leap, which is purely a case of me trying to find somewhere to put a particular response.
Before we come to the leap, just a matter of detail, can you remind me if what we're talking about is a temporary measure or something that should have been in place on a permanent basis?
Oh no, it's a tool to be used. Of course, there's a very difficult decision about when do you turn on an executive control group, because you clearly can't have one the whole time. That would be terribly inefficient. But we do have evidence about the establishment of things called gold command groups and silver, and that's not an unusual part of incident management in public services now. And then they don't exist all the time.
Yeah.
So they exist when they need to exist.
Sorry, I interrupted
No,
you.
well, I then, of course, made
you were
this big
about to
leap.
take me to section 51.
So the reason I take the leap and the reason I put it here is because as we develop at some length in our submission, and I won't repeat this, there was some evidence that when the decision was made to take the board to stage 4 of the national framework, there was discussion about whether to go higher at stage 5. Ms. Freeman gave evidence about this, and we asked Mr. Wright, who'd then been Director General, about it. Now, Ms. Freeman was very open that she decided not to at the time, and I think she gave the impression she might have slightly regretted that on reflection. And it was our submission that the government should review its toolbox of materials, of methodologies, so that it has some method, in the case of the largest health boards, of doing more than simply imposing an oversight board in a practical way, because we could well understand Mr. Wright's evidence of how impractical stage 5 of the framework could be. And so my response to Ms. Crawford's submission is simply this. When we reviewed the legislation to draft our submission, we did not envisage the Scottish ministers employing anybody. The Scottish ministers routinely set up bodies, appoint people to bodies, replace members of bodies, all applying relevant statutes. And in our submission, this is the same sort of thing. And that section 77 and 78 of the NHS Health Service Act could be adjusted to give a more practical toolbox. And it doesn't need to step over the boundary of addressing reserve matters, which of course will be difficult for law as well, or employing people who the Scottish Government isn't permitted to employ. This might be an appropriate moment to stop for a break for coffee, because I've reached a short gap.
Are you on track?
I think I'm a little bit ahead of time, my lord. As you all knows, I operate a system of written notes and pages, and I have 31 pages on page 25.
Right. Well, shall we, again, I think there's probably a bigger demand on coffee than on some days. So if we were to sit again at 10 to 12.
I'm sure I'd finish by lunchtime, my lord.
Thanks,
Right, last one, didn't I?
Mr. McIntosh.
Well, during the coffee break, we were reflecting, Mr. Connell and I, on the impact of the opening of the hospital and the submission by GGC in paragraph 6.14. And I think there can be a clear line be drawn, which is in respect of the problems that we identify with the ventilation system. So that's the air change rates not being according to guidance, the wrong sort of isolation rooms, even the lack of HEPA filtration in the housings in Ward 2A. The fact that the hospital opened on time as scheduled has no impact because fundamentally the ventilation deficiencies were not understood at that point by many of the people in GGC, particularly outside the project team, and had been forgotten, I think you can infer, within the project team. When, however, you turn to the water system, it's more nuanced. We know that simply because of where a large construction project can get to, by accepting the hospital on the day they did, in order to meet the long-planned schedule for the moving of all the services across Glasgow, the consequence was there were lots of contractors on site. And a number of the estates and facilities witnesses who gave evidence, largely in Glasgow 3, described the effect of that large number of estates people. But of course, it's now a GGC building.
Sorry, a large number of contractors.
Sorry. It's now a GGC building. So they have
the estates people is
there's too few of them.
Yeah.
So it's now a GGC building. They have to be managed. They have to be kept an eye on. I mean, in certain areas, they have to follow infection control HI scribe procedures. The very simplest, there have to be logs kept of who's there and what they're doing. The effect is, of course, that the limited size estates and facilities team, which is already too small, is placed under a higher degree of pressure. Now, in our submission, it's a reasonable inference to think that putting that small estates team under a higher degree of pressure before opening, which of course is the time when the DMA Canyon report is being finalised, may well have had an impact on the well-described failure to act on its recommendations and escalate it within the organisation. But the pressure was to open as scheduled. And that pressure was, as far as we can tell, not made by people who knew about the ventilation derogation and the other deficiencies. For the simple reason that by 2015, outside the project team, people didn't appear to really know. I hope that assists in the question you asked before the coffee break.
Yes, and that's
Yes, so the next section, taking the headings from Professor Cudahy's statement, is the cost of complacency. Now, I've already described, and we've described in our submissions, the not asking of questions, and the board has accepted the failure to manage the water system has a connection to harm experienced by patients. And we say that for certain patient groups, some of the ventilation systems pose risks that require to be properly assessed and managed. And we've identified many occasions when senior staff and directors of NHS GGC fail to ask questions, to an extent that we've already said before the coffee break, amount to willful blindness, or you can see it as a sense of complacency. But there are a couple of further examples that arise after the water incident, one of which is rather recent, that fit into that idea of not asking questions, of challenging those who ask questions of you, what you might see as a form of complacency. The first is the response to the case notes review in March 2021. As we saw in evidence in Glasgow 3 and Glasgow 4, key NHS GGC staff, up to and including director level, did not want to accept the conclusions of the case notes review on infection link. And as Mr. Connell has set out, directors would appear to have decided to keep quiet on the matter rather than face up to the conclusions on infection link of that distinguished and capable group. So that's an example of a response to being challenged, rather than accepting that there may be some merits to it, giving it credit for its expertise and the detailed level of its work, instead pushing back, perhaps complacently. But this more recent example is the...
Sorry, use this as an example of, well, I suppose, yes, and I'm with you. Complacency suggests inaction, but I see that if one is complacent, one might just reject the whole proposition that things, to some extent, may have gone wrong.
So complacency could cause you to not ask questions, and therefore could be, and if you do it enough and frequently enough, it becomes a culture. And if that complacency is happening when you have been told things that are a problem, then it becomes willful blindness because you know about it, but you're still not looking. But equally, when you are challenged, when someone says, here is a problem, if your response is to push back, to not be open to ideas, then that is an aspect of complacency. You're complacent in your own position and your own certainty. And so one example, which I've just discussed, is the response to the CNR. But a second one is that SBAR, the one prepared in November 2024, thank you, and sent to the Director General of Health and Social Care by Professor Gardner. Now, it reads that faced with questions and opinions from experts and people of skill, the IPC senior management team of the board, again, respond with accusations of bad faith and denial that a problem exists. And this has to be seen along with the general conclusion that I think we're not entitled to conclude, that it's been repeatedly the case that when microbiologists and others raise issues relating to patient safety linked to the hospital in the field of infection prevention control, they've been rebuffed or ignored and had their views minimized. And in my submission, that speaks of that complacency.
I wondered if, just reflecting on the November 2024 SBAR in the name of the Infection Prevention and Control team. And I heard a submission from Miss Watts as to who I should understand the team to be. That was addressed, of course, not to Professor Gardner, who was not in post at that time, but to the then Chief Executive, Jane Grant.
It was, and I asked the questions about that.
Yes, right. I wonder if, when one looks at the language used, particularly at the last section of the SBAR, it would be, one would be entitled to draw an inference as to what the terms in which they express themselves to the then chief executive, would it be fair to assume that the authors must have thought, well, they must have thought what is stated, but they also thought that, having regard to the nature of the organization they were in, that it was appropriate to use that sort of language in a communication with the then chief executive?
Yes, it speaks to the concept of an in-group and an out-group. That, I mean, we all do this at times. When you're in a team, you discuss events in a different way within the team as you discuss them with other people. That's the nature of working life or humanity. But in this case, in my submission, that document, at the very highest level, describes as is written from a perspective of certainty. We can say these things, no one's going to push back. And in my submission, that's what worries me about this. It's a repeated feature. And it's going to be very difficult to shift. I should say that when that document arrived in the inquiry office, we did ask the lawyers for the health board who the authors are, and we have an answer. And broadly speaking, I think Ms. Watt is correct, but I'm sure that can be passed to Lord. It's not our habit to bundle these one-line emails that we get from, and they're very prompt in responding generally, the lawyers for the health board, to bundle them, but we were given the names of the authors by the health board solicitor. The professor's next heading is a demand for accountability, and I thought this would be a good place to discuss an issue that you discussed with Mr. Love yesterday on accountability and how it should work. Now, Professor Cudahy points out that the NHS Scotland Blueprint for Good Government mandates that executives should be held to account for failures. And when he gave evidence, Professor Brown talked of the importance of this. Mr. Connell discussed it when he gave evidence, when he made his submissions at the opening of this hearing on Tuesday. The fact remains that no one in that in-group has been held to account by NHS GGC. The only people challenged by NHS GGC for their decisions appear to be Dr. Redding, Dr. Inkster, and Dr. Peters. Now, it remains our position, as expressed by Mr. Connell on Tuesday, that the position of NHS GGC on personal account responsibility is untenable, given the reality that harmful decisions or actions or failures to act, described in our submissions, were carried out by individuals, either alone or in groups, as part of their duties. And I wanted to respond to paragraph 7.1 of the NHS GGC submission and the section that follows afterwards. If I understood what Mr. Gray was explaining on Wednesday, his submission was that it would be appropriate to criticise individuals involved in the procurement and construction, but not those involved in the response to infections, due to the intensity of the events as they sought to respond to a complex, unprecedented situation. And that is set out in 7.1, but it flows through the rest of the submission. And we have some difficulty in understanding the line that's been drawn here. So, firstly, there's no clarity about when this complex and unprecedented situation began, and therefore the point after which individuals should not be criticised. In our submission, the only possible date for the start of such complex, serious and unprecedented incident is the start of the water incident in 2018. It can't be the reaction to the opening of the hospital, because they accept criticisms of the procurement team. So if March 2018 is the start of the incident...
Sorry, not prior to the...
it can't be it can't be that this intensity of the incident also applies in 2015, because if I understand the GDC position now is that it's appropriate to criticise members of the project team. So if it is correct that this incident of such intensity and seriousness starts in March 2018, and there was a serious incident that started at that point, then that, of course, would enable, if justified and necessary, the making of criticism of individual actions prior to that date, because the explanation, the mitigation of the incident wouldn't apply. And of course, that would include the defensive responses of NHS GDC managers and the medical director when faced with ICDs and microbiologists who wish to raise concerns about the ventilation of water system. Most principally, the response to the issues raised by Dr. Peters and Dr. Inkster when they sought to demit office as sector ICDs in July 15. Secondly, whilst it must be correct that from March 2018, individuals were responding to a complex, serious, and unprecedented incident, and that may well explain or even mitigate conduct that could otherwise be criticised, it must be the case that it can only do so when the conduct complained of has a plausible link to the intensity of the event. And an example of an unconnected event might well be the way that the report into Dr. Redding's stage 2 whistleblow turned into a critique of the failings of Dr. Peters' conduct. There's no basis to suggest that that was impacted by the intensity of the water incident. If criticism of the author of that report is necessary to deliver on the inquiry's remit, then it would be justified and wouldn't be excused, as it were, by the water incident.
There is, just listening to you, perhaps another problem. As I understand it, Mr. Gray presents a sort of moral culpability test. He accepts those involved in procurement and supervision of the contract might be appropriately individually blamed, I think, because that's a less pressured environment in which they're working. But there is, as I understood it, less moral culpability to be attached to someone who is doing the best they can in difficult circumstances and perhaps making a mistake. Now, I come to my point. If one has heard evidence from candidates for personal attribution of responsibility, who in their evidence may make general points about difficulties in which they were trying to respond to, but do not say, well, perhaps things could have been done differently, but I was so pressed at the time. In other words, if one is to apply Mr. Gray's criterion, does that not require an evidential basis? In other words, looking at what the candidates said in their evidence.
I don't think you have to limit it to what the candidates said. You don't have to have insight, is what I'm suggesting.
But if the candidates don't say anything about it,
it's better if they have insight, I think, is the way of putting it. One of the quandaries that the council team are worried about a lot is, and I won't name them because it would be general antithesis to the point I'm trying to make, but one can conjure up the names of a number of people lower down in the organizational structure who have failed to do things, done things not particularly well, failed to understand things, or done things wrong that have bad effects. And yet, when you either look at their experience level and their position in the organization, or you look at the pressure they were under in terms of, particularly in estates teams, the resource implication, and you notice that they've only done one thing that we're criticizing them for, it becomes, in my submission, slightly unfair to do anything other than note that the thing they did or didn't do had a consequence, but to make it clear that either they were well out of their depth, maybe they were asked to supervise water when they were an electrician, maybe they hadn't received appropriate training, maybe there weren't enough people available. Now, sometimes that will come, and obviously there's an excellent candidate in the first few weeks of Glasgow who absolutely accepted that he'd made a mistake. Mm-hmm. But there are other candidates who didn't really accept they made mistakes. But when you look at what they actually had as skill sets, it's hard to entirely blame them. And I think I had a section which I didn't say, but I think I can use it here. If you look at the project team and read our submissions on the project team, there are people on the project team who were clearly well out of their depth. Is it entirely fair to blame them for being out of their depth? To some extent, everyone should have the insight to say, why am I doing this? This is well beyond my skill set. But equally, the people who put them there have a much higher level of responsibility. So, but that, in some senses, that distinction applies to my criticism of Mr. Gray's threshold, because the third part of the criticism is that if you argue that the action or failure to act was affected by the intensity of events, and therefore you shouldn't criticize them, in my submission there are two limits. The first relates to the extent to which the individual involved had authority or control over the events, or even if their actions made the events worse, intensity of events worse. In essence, it's harder to complain that your individual action or inaction are excused by events you make worse, or when you have a high level of executive responsibility for the whole response. And some of the people involved in the 20th of August 2019 meeting that decided to remove Dr. Inkster would definitely apply to them. There's also a second aspect. If the conduct that you've done or you've not done is something you've been doing for years, the fact that you did it during a moment of intensity ceases to be mitigation. And again, without naming the managers involved, I think one can usefully look at a couple of examples of relatively senior managers who applied the principles of exception management and not asking questions over many years. The fact that they did some of those, they failed to ask questions during the water incident, can't be explained by the intensity of the water incident because they've been doing it a long time. So where does that take us? In our submission, we've identified a number of such individuals in our closing statement and said what they did and why it had harmful effects. I know my Lord will wish to be fair, and I would invite my Lord to apply the approach I've just described to the question of whether to identify them. Of course, one should only identify people where the thing they did requires to be identified in order to give effect to the terms of reference of the inquiry. And in broad terms, I would adopt Mr. Love's careful submissions on the importance and necessity of identifying persons responsible for significant and relevant failures. Because if you, my Lord, was not to identify individuals, as Lord has said in questions, the whole exercise becomes academic. And ultimately,
sorry, what exercise?
The exercise of working what went wrong. If you work out what went wrong and you describe it as a management failure, as a systems failure, then no one ever learns, because human beings think by stories. You have to be able to tell the story completely, and it's only by understanding the personalities and the pressures they're under and the pressures they cause that you can really understand what has happened. The professor's final heading is leadership accountability, what he calls the missing link. And I would commend his plea for leadership accountability to my lord. And given the board's position that it has learnt, that it has changed, the inquiry requires to consider whether you, my lord, can accept that that change is real and effective. And this is where the work we asked Sir Robert Francis to do comes into play. There have been no shortage of incidences, often in the health service, but not always, where organisations have been seen to fail and where individuals in those organisations have drawn those to the attention of those in charge, have been rebuffed or minimised or had detriment, and the organisations have not changed, at least in the short term, and things have continued to happen to the detriment of patients or users or whatever. Now, there is no shortage of policies or guidance in this area. And indeed, it's not my lord's remit to suggest new national policies in this area. This isn't an inquiry into whistleblowing directly. It comes in through term of reference 4. So why is it that health organisations and others keep deflecting and denying evidence when faced with evidence of risk of patient safety? And in our submission, it's a lack of leadership accountability. Senior leaders effectively need to know that if they show willful blindness or complacency or don't ask questions when patient safety issues arise, in due course, they will be held to account in a meaningful way. The Lord will have read Sir Robert Francis's report for the inquiry in Bundle 51, Volume 1. We sought the report not to have him reach conclusions, because he's not a part of the panel, but to give my lord an accessible way to have access to his long experience of investigating the role of whistleblowing and the importance of speaking up and having safety in doing so. And in his report, I was struck by the way that he started his explanation from, as it were, the ground up, with the 7 Nolan principles of public life. That of selflessness, integrity, objectivity, accountability, openness, integrity, and leadership. And without accountability, they have no value. They just become words that people talk about in meetings. In our submission, when you talk about the senior people, the director levels, the board level members, the Lord should ask whether those individuals conducted themselves in a manner consistent with the Nolan principles. Now, on Tuesday afternoon, Mr. Gray stated that lessons had been learned. And in the closing statement, I looked for references to lessons being learned. And if we look in the in paragraph 17.3, after expressing profound regret for those who have experienced distress, anguish, and suffering as a result of the events. Firstly, I would emphasise the first sentence doesn't contain an apology for the actions of NHS GDC. It is a matter of profound regret that those who NHS GDC care for have experienced distress, anguish, and suffering as a result of these events. It doesn't say as a result of the failure to act of the board. NHS GDC offers an unreserved apology for the distress and trauma experienced by actions and families during this time. That's an apology for secondary consequences. There's no apology for what the board did. NHS GDC has listened to the evidence of all those impacted. Indeed, it has. It has been represented every day of this inquiry, and we understand that members of staff have viewed this inquiry within their offices. Shortcomings have been identified, and there are shortcomings identified in this submission. Lessons have been learned. Now, the reference to lessons has been learned also occurs in paragraph 810. It's not 810 at all. On paragraph allow me a moment just to find my reference, because that is not the right paragraph. There isn't a paragraph 810, so I must have mistyped.
Certainly not in.
Just allow me a moment to
statement.
get the document on the screen. Sorry, 310. This is a quote from the first NHS position paper. We don't need to put it on the screen because it's set out in paragraph 310. And in the second sentence, it states the board's position throughout has been, and then there's a quote from the positioning paper. And from the second last line of that quote, it says, lessons have been learned. But in my submission, at no point, either back in December 2022, when the board was challenging the infection link, or now, when it isn't, have these lessons been actually identified to the inquiry in a formal sense. The witnesses certainly didn't identify the lessons. Knowing what the lessons are would help to give confidence in which is otherwise a bald, unsupported assertion. But we don't have that. In fact, in our submission, there is precious little to suggest the board has really changed. The words are there, and we have yet to see any real action to suggest that anyone other than its chair and chief executive, who I would definitely accept from the criticism I've just made, there is any real appreciation of what needs to change, let alone there's been real change in both culture of the organisation and how it has responded to the evidence laid before it over the past decade. In our submission, at a minimum, 3 things need to change.
Perhaps we shouldn't get too hung up on, well, start again. The 3.10 quotation is the board stating its position as to what the purpose of the inquiry is.
It is, and what it's saying then is that its lessons have been learned.
Well, is it?
No, that's a fair point.
I mean...
Yeah, no, I see what you mean, Lord, yes.
I mean, if we look at that, that's the board saying that from its point of view, this is what the inquiry should do. And among the things the inquiry should do
is find out what the lessons have been learned.
Is where mistakes have been made. Therefore, the inquiry has to determine whether or not a mistake is made.
You're right, my lord. I should.
And whether lessons have been learned. So, I mean, it's, if anything, it's holding the inquiry to its task.
Yes.
I mean, it's what the board is saying there and repeating in its final closing statement is that this inquiry has to determine whether or not mistakes have been made. And if it determines that mistakes have been made, that lessons have been learned. Now that would seem to, if anything, to elevate the bar as to for the inquiry to assure itself that lessons have indeed been learned.
It would do, but it would undermine the point that I was making, which I need to row back on slightly. The current position of the board is that they have learnt lessons.
Yes.
I think I'm unfair to suggest that they were saying in December 22 explicitly in that text that they had then learnt lessons. But
No, I don't think they are saying that.
No, but I think it is fair to say that when their staff gave evidence, senior staff, there wasn't a lot of evidence of what the lessons were. And the point I'm making is that some clarity now, after the change of position, about what the lessons have been learned are, would I think have assisted my lord in understanding whether the change of position is effective and real. And I then went on to say that, accepting, of course, that the current chair and chief executive, based on the chief executive's evidence, clearly understand there needs to be a change, we haven't seen any evidence that the rest of the organisation, whether it's the board itself, the other directors, the managers, senior clinicians, do understand what lessons they have learnt. Because up until October the 9th, they weren't accepting, in some respects, there were any lessons to be learned around certain aspects of the inquiry's work. And it's because of this lack of detail, this reference to, for example, policy changes and governance changes that occurred prior to the change of position, that we worry that the change isn't real, that it is from the top down. And that isn't to say that that Professor Gardner clearly has an important and difficult job to do to change the direction of the board. And it would be wrong to do anything other than to acknowledge that will be a difficult task for her and the chair. But in our submission, in order for this change to be real and effective, three things have to happen. Firstly, there has to be accountability when mistakes are repeatedly made, or when complacency and failure to ask questions repeatedly happens. Everyone can make an isolated mistake or fail to act, but that's not what we're talking about here. Those who repeatedly fail to act or question over many years, when there was a good reason to do so or when they were on notice there was a problem, need to be held accountable for that. When key people have retired, then unfortunately the ability to do so will fall entirely upon this inquiry by making findings in its final report. There needs to be a cultural change in NHS GDC. That will have to come from the top. Professor Gardner says she wants to change the organisation. In our submission, to do so, she has to demonstrate that that change has started and give a clear and cogent explanation of why change is needed and what lessons are learned. Our recommendations in paragraphs 1900 and 1901 are designed to do just that. The board does not have to wait until my lord reports. It could act now to make the public statements and apologies we've described in broad terms in paragraph 1901, and start the work to retrain the board members and members of the corporate management team in the manner we propose in paragraph 1900. Such action could, of course, be criticised as coming very late, but they would show a direction of travel which might enable confidence in the board to recover, even now. Thirdly, NHS Greater Glasgow and Clyde has to know that the Scottish ministers will not tolerate a failure to change. Over the two occasions she gave evidence, Ms. Freeman acknowledged that there is to some extent an inconsistency between the devolved and local nature of health boards and the reality that the people of Scotland see the Scottish Government and the Scottish Parliament, from which it comes, as holding ultimate responsibility for the health service in this country. In our submission, the Scottish Government and NHS NSS need to have the tools to deal with health boards that persist over many years in maintaining that everyone else is wrong in the face of the evidence. Without such better tools, something like the events that have been the focus of this inquiry are likely to happen again. Now, I don't propose to revisit Mr. Cole's response to Mr. Love's proposal that the inquiry continue to exist after the report is produced, other than to draw attention to our proposed recommendation that paragraph 1906 that is addressed to the Health, Social Care and Sport Committee of the Parliament, in which we propose that the committee conduct a review 18 months after the publication of the final report to the extent to which its recommendations have been implemented. Well, that concludes the substantive element of my submissions. I've got one final remark to make. Is there anything else I can assist with?
No, I don't think there's any question that occurs to me.
So at this point, my Lord, can I just take the opportunity to extend my thanks to the witnesses, the inquiry team and the legal teams supporting the court participants, and also to you, my Lord. And with that, you have the submissions of the Senior Counsel of the Inquiry team and my submissions, unless there's anything further I can assist you with.
No, thank you very much, Mr. McIntosh. Now, turning to address the room, as Mr. McIntosh emphasized at the beginning of what he had to say, this is not the end of the inquiry. There's much work for me and the rest of the inquiry team still to do in preparing a final report, albeit that counsel to the inquiry have carried out their part in the work of the inquiry. So it's not the end of the inquiry, but it's the last occasion when the inquiry is at, as it were, public facing. And I would accordingly wish to take the opportunity to make a few remarks. I have heard the evidence of, I think, 186 witnesses. Now, all that evidence has been helpful. Some, as legal representatives have acknowledged during this last week, has been very powerful and very moving, and consequently effective. Can I express my thanks to all the witnesses who gave evidence and provided witness statements? And perhaps I should particularly acknowledge their patience with me as I slowly learned from their experience and, in many cases, their expertise. But in thanking the witnesses, can I also thank those who, typically in core participant organizations, but more generally as well, have assisted the inquiry in responding to requests for information and providing the many thousands of documents that the inquiry has considered. Now, these will typically have been individuals within organizations who had to maintain their day job at the same time as assisting the inquiry. Can I also thank the legal representatives? The legal representatives in this room who present the public face, as it were, of core participants, but also the legal representatives instructing those counsel and others who have made oral presentations. I know I speak for the solicitor to the inquiry, who is indeed sitting in the room, when I say that the inquiry has been very appreciative of the cooperative and highly professional conduct of those in solicitors' offices who instruct the legal representatives who appear in the inquiry hearing room. Mr. McIntosh gave an example, and this of how quickly Central Legal Office had responded to a particular request, and the solicitor to the inquirer's experience with the Central Legal Office has been universally good, but his experience with all other solicitors instructing those present here has been equally good. And I'm appreciative of that and would wish to add my thanks. Can I also thank counsel to the inquiry, their junior counsel, and every member of my inquiry team, each of whose work has been essential to bringing this inquiry to its present stage. It is only a part of the inquiry's team's work, but organizing the hearings in this inquiry is a very substantial task, including IT support, management of those, or support rather than management, to those engaged. And I may be wrong, but I cannot recollect a day that has not proceeded to timetable. Now, that is not true of every forum by any means. It appears to me that the inquiry team have done a remarkable job, and I'm very grateful for that. As I've said, while counsel have played their part, there is much work for me and the rest of the inquiry team to do before we're in a position to submit a final report to the minister. And so that is what we must set about doing. But with that, can I wish you a good day?
Please stand.